Will Israel be held accountable for genocide? Welcome to Connections, the Arab Studies Institute's interview program. I'm Mouin Rabbani, and for this episode, we're delighted to be speaking with Ardi Imseis, Assistant Professor of Law at Queen's University and author, most recently, of the United Nations and the Question of Palestine. Ardi Imseis, it's a real pleasure to welcome you, to welcome you back to Connections.
Thank you.
I'd like to start by asking you to help us understand the concept of genocide, because we're now talking about a legal case before a court of law. And I think genocide probably means different things to different people. As a matter of international law, and in terms of the Genocide Convention upon which this case is based, what is genocide? And specifically, how does it differ from other war crimes and crimes against humanity? Is it a question of scale and scope? Is it a matter of intent? What distinguishes and defines genocide?
Oh, well, thanks for having me again, Mouin. Yeah, I guess the first place to begin is to situate genocide within the pantheon of what we call in international law the core crimes. And indeed, when you're dealing with states, internationally wrongful acts. And these would be war crimes, crimes against humanity, genocide, and aggression. For the purposes of today's chat, I don't think aggression is as relevant as the other three, but just to situate these things, war crimes are generally understood to be grave breaches, what are known as grave breaches of the Geneva Conventions of 1949. They are codified in those conventions. They're also codified in the Rome Statute of the International Criminal Court. And these are, in lay terms, discrete acts, sort of individual acts, say willful killing of a protected person or a civilian person, or the torture of an individual or group of persons, and so on. So discrete and individual acts that violate the laws and customs of war, grave breaches, those are war crimes for which individual criminal responsibility attaches and flows. And then you have crimes against humanity, sort of moving up the scale in severity. Crimes against humanity are similar acts, right? They could include murder, extermination, deportation, or forcible transfer of a protected population, things that incidentally are taking place in the Gaza Strip and have been taking place in the occupied Palestinian territory for many a decade. But the thing that differentiates crimes against humanity from war crimes is that these acts must be committed as part of what we call a widespread or systematic attack directed against the civilian population, and most importantly, with knowledge of that attack. And so the next question is, how does any of this differ from the crime of genocide? And for there,
but before you go there, is a crime against a war crime, I presume, needs to be perpetrated in the context of armed hostilities. Is a crime against humanity one that can be committed either during a war or outside the framework of a conflict?
Quite right. Very good point there. You're right. More often than not, they would be committed in times of armed conflict, but they don't necessarily need to be. And the same is true with genocide. Genocide can take place either within an armed conflict or outside of an armed conflict. War crimes tend, again, very narrowly to focus on periods of armed conflict, non-international or international. Now, when we go to genocide, the difference there is that, again, moving up the scale of severity, if you like, is that you have a series of acts, right? Killing members of a group, for instance, might be one of them, or causing serious bodily or mental harm to members of a group, or deliberately inflicting on the whole group conditions of life calculated to bring about its physical destruction. But what separates genocide from these other actions, war crimes, crimes against humanity, is that those actions must be accompanied by an intent, and that intent is to destroy in whole or in part a national, ethnical, racial, or religious group as such. Forgive the archaic term ethnical, but in effect it means ethnic group. And so that is the difference between these things. And the consequences of international law for the commission of both war crimes, crimes against humanity, and genocide, and indeed aggression, differ depending on whether or not we're focused on individual criminal responsibility, that is, the responsibility under criminal law of individuals who commit or order the commission of these actions, and states, on the other hand, right? Because states are not criminal as such under international law, although members of states, say individuals who act on behalf of states, can engage in criminal actions that attach to them as individuals.
Like
and when you're dealing with
decision-makers
states,
or military commanders.
correct, with command responsibility. And so when the state is alleged to have taken part in any of these actions, say genocide, the results are that they must cease the internationally wrongful act, which is what it is called, of the state. Now, keep in mind, just as in the municipal law or domestic law, you can have one set of facts give rise to both individual criminal responsibility and, at the domestic level, tortious responsibility. And in international law, it's sort of similar. You can have a similar set of facts that give rise to individual criminal responsibility of persons who act on or as agents on behalf of the state, and also give rise to state responsibility.
Where it's state policy.
Correct, where the state is then held responsible for the internationally wrongful act, in this case of committing genocide or failure to prevent genocide.
So we're talking about the difference, let's say, between a rogue commander wiping out the population of a village, or him receiving orders to commit those acts.
Yes.
To simplify things.
That is actually an oversimplification, because do keep in mind, I don't want to get too technical, but even the event of a commander, a local commander on the ground committing a war crime, would give rise to individual criminal responsibility in respect of that commander, because the commander is acting as an agent of a state. The state too would attract, through those actions, state responsibility for the internationally wrongful act committed by that individual.
And just to clarify also, what distinguishes genocide from some of these other crimes that you've described, it could in practice be exactly the same act, but would require intent and an intended result to be classified as genocide. So the real distinction is less what you're doing than why you're doing it.
Yes, I'd say in general terms, yes. The most important, the crucial element that separates genocide from the other core crimes is the intent to destroy, in whole or in part, a national, racial, ethnical, or religious group as such. And that is a very, very difficult thing to establish in international law.
Yeah. And the reason we're having this discussion today is because South Africa has now gone to the International Court of Justice and accusing Israel of perpetrating genocide in the Gaza Strip, and seeking action by the court on that basis. So my next question would be, why is the International Court of Justice involved? What is a genocide convention? South Africa does not appear to be a direct party to this issue. So why is South Africa why does it have a mandate to act in this case? Could you perhaps walk us through that?
Sure, absolutely. So under international law, there's a treaty that exists. It's entitled the Convention on the Prevention and Punishment of the Crime of Genocide. And we know that only states who are party to the treaty are bound by it, but because genocide is also an internationally wrongful act and an international criminal act that is a codification of custom through this treaty, all states are bound by the custom to prohibit, prevent, punish genocide. Now, going to the treaty itself, South Africa is a party to the treaty, so is Israel. And under Article 9 of that treaty, I'm reading here, this is what we call a compromissory clause. The treaty furnishes parties to the convention to submit any dispute between them relating to the interpretation, application, or fulfillment of the convention to the International Court of Justice for adjudication. indemnification, all right, in the event that there is a dispute. Keep in mind, because of the importance of the crime of genocide, it is what we call a peremptory norm of international law, derogation from which is not permitted. It gives rise to obligations of all states, but when we're speaking of this particular treaty, all parties to the treaty to prevent the crime of genocide. See Article 1 of the treaty, where all parties confirm that genocide, whether committed in time of peace or war, is a crime which they undertake to prevent and to punish. So it gives rise to standing in South Africa, and indeed any other party to the treaty, to call Israel to account over a dispute concerning the convention. And so this compromissory clause has been, if you like, the entry point through which South Africa has brought this dispute to the court, the ICJ, for what will be a binding decision or series of decisions as between it and Israel.
And South Africa's argument then is that it has a positive obligation as a signatory to the Genocide Convention, even though it is not affected by Israel's actions. It has an obligation to bring this case because of Israel's violation of that convention. Is that correct?
That is correct. And I should suggest to you, that it's even beyond an argument. Of course, that's what the South Africans have said in their submission. But it is self-evident that based on the clear object and purpose of the terms of the convention, that all parties to the convention have standing to do this. And so South Africa has. When you're dealing with the core crimes, especially genocide, but not alone, all states have standing to pursue them, prosecute or extradite, both in treaty law and in customary law.
And there's precedent here because several years ago, it was the Gambia which brought a case about genocide against the Rohingya in Myanmar. And Gambia never claimed that it was itself in any way affected by the actions of the government in Myanmar.
Yes, not materially affected, but again, as a party to the convention,
it was a party to the convention,
they are
but not
affected.
to the conflict.
Exactly, they are affected because they have an obligation. States parties to this convention have individual obligations to ensure, that is, to prevent and punish genocide, and to the extent that they fail to do so, that implicates their obligations under the convention, under international law. And so that's why South Africa has done this.
And if you could now walk us through the process. South Africa has filed an application. It asked for the court to convene on an urgent basis to consider this application. What should we expect to see in the coming weeks, months, years? How is this process going to go through the International Court of Justice?
Sure. I suppose the first thing to start off with is to keep in mind that the ICJ is only open to states. And the ICJ exercises two types of jurisdiction. One, advisory jurisdiction, where the court might be asked a question by a body that is authorized to put that legal question before it, and it will offer an answer to that question. And if it does, that would be an advisory opinion, formally not binding, but to the extent that such an opinion is based on customary international law, would be binding. This is the second type of jurisdiction, which is a contentious case. And under this convention, through this compromissory clause, Article 9 of the Genocide Convention, there is now a dispute between two parties to the convention. That is Israel, on the one hand, as defendant state, and South Africa as applicant state, as respondent state, forgive me, and South Africa as applicant state. And whatever the court decides in the case, and there will be a series of judgments that issue over time, will be binding on these parties. Now, what can we expect? Hearings have been set for the 11th and 12th of January, and they've been set on an expedited basis at the request of South Africa for one particular reason, that events on the ground are overtaking everyone. That if indeed South Africa's allegations of genocide being committed by Israel, or failure to prevent genocide by Israel or other states, it is in fact rolling out, then it behooves the court to act quickly. Now, South Africa has asked for two, if you like, broadly processes to take place. First, for the court to hold these hearings on an expedited basis, which they will do, in order for it to issue what is called a provisional, a provisional measures order, forgive me. And the provisional measures order is somewhat akin to a domestic law, an injunction, an order that is given by a court on short temporal order, immediately or very soon after proceedings have been issued, for the purpose of basically making sure that the rights of the parties to the litigation are preserved going forward. And in this case, what are the rights that need to be preserved? Well, the right of the Palestinian people to life, to not be subjected to genocide. So the goal of seeking a provisional measures order by South Africa from the court would be for the court to issue a reminder to Israel of its obligations under the Genocide Convention, including to prevent genocide from taking place, to prosecute incitement to genocide, and indeed to not engage in acts of genocide. And this may very well be a call from the court in a provisional measure order to cease fire.
And I think South Africa explicitly requests this in its
application. Indeed. Now, so that's the provisional measures stage. We can get into the law on that and the likelihood of a provisional measures order being issued and what it might look like. But then looking forward, keeping the broader picture in mind, looking forward, then there would be the issue of the merits, right? What is the case on the merits? That is to say, is in fact the Genocide Convention being violated by Israel, either through its failure to prevent the commission of genocide, either through or its actual commission of genocide, and so on.
Let me just interrupt you.
Yes.
Just to clarify, the court does not need to determine that a genocide is in fact taking place in order to institute provisional measures. It only needs to find that South Africa's application is reasonable and is within the mandate of the convention.
Yes, at this stage. In fact, the test is plausibility, right? Not reasonableness, but plausibility. So at the provisional measures stage, the threshold is very low. The evidentiary threshold is very low to establish a plausible case that
better
genocide.
Safe than sorry.
Exactly. And the idea that this makes sense. The idea is to issue an immediate order to preserve the rights of the parties, and in this case, preserve the rights of South Africa to under the convention, that is to prevent the commission of genocide, preserve the rights of the Palestinian people in particular, who are the group that are the subject of the alleged genocide, to not be subjected to acts of genocide and so on. And so that's why the evidentiary threshold would be low. Plausibility is the threshold. We can talk about the law there in a moment. But then again, looking forward, the question will be at some stage, say 2, 3, maybe even 4 years hence, the court will have before it all the evidence that will be proffered by the parties to the case, South Africa, Israel, which is returning to the jurisdiction of the court now and is going to submit. We'll have to look at the evidence and assess for itself on the merits whether or not the claims made by South Africa are in fact true. And there, the evidentiary basis is much, much higher. There can be, under the law as it is established, there can be no other inference capable of being drawn from the acts alleged to taking place by Israel that lead to anything other than genocide, right? If there is any other reasonable explanation for Israeli actions on the ground that have been complained by South Africa in the Gaza Strip or elsewhere in the occupied Palestinian territory that come before the court, then it will not, the threshold of genocide on the merits will not have been established.
And intent is once again centrally located.
Of course, intent is centrally located, right? So we can get into what that might look like both at the provisional measures stage and the merits stage, but I can say straight off the bat, based on the jurisprudence of the court, it is very likely that a provisional measures order will issue and will issue in either the 3rd or maybe 4th week of January. And it will remind both Israel of its obligations under the convention and South Africa of its obligations under the convention, in this case, to prevent the crime of genocide and to punish it and so on. And it may very well even go beyond that to remind all parties to the conflict, whoever they may be, of the need to ensure they don't engage in acts of genocide.
And
I'm speculating there.
yes, but okay, well, for the sake of argument, if it does then also remind other parties of their obligations under this convention, does this create the possibility that other countries can then be accused explicitly of complicity in genocide before the court?
In litigation, anything is possible. The parties to any litigation will throw up all arguments they can, and there was some consideration that Israel would not torn or submit itself to the jurisdiction of the court, that is, appear before the court, even though it's already submitted itself by virtue of being party to the Genocide Convention in Article 9. But it is clear from the press statements that are coming out of Tel Aviv and elsewhere over the past 48 hours that Israel has not only decided to go before the court, but that they're going to throw a lot of energy behind their case, of course. They will also name a judge ad hoc, which is the right of any state that finds itself before the court in a contentious case and does not have representation on the bench, that is on members of the judges that sit on the 15-member court. So Israel will go through the process of not only appointing counsel, but also a judge ad hoc, which will sit on the bench for it. South Africa will also likely appoint a judge ad hoc. So there will be 17 judges. And you bet your bottom dollar that the Israelis are going to throw all manner of argument up before the court, including pointing fingers at Palestinian paramilitary groups for the commission themselves of genocide or attempted commission to genocide on the 7th of October. I would be surprised if they didn't do so. There are technical reasons that would limit the extent to which Israel might, for instance, be able to point the finger at the state of Palestine. Keep in mind, the state of Palestine is also itself a signatory to the Genocide Convention, though not a party to these proceedings as yet. So to the extent that Palestine remains outside of these proceedings, we don't know where that will go, but to the extent that it does, then it would be difficult for Israel to point the finger at the state of Palestine as such. And if they did, then there would be defenses for Palestine based on jurisprudence of the court, the monetary gold rulings, which basically affirm the following: that no state in a contentious matter before the court can be brought before the court without its consent. So there might be other means to bring other states before the court. There could be counterclaims against South Africa, which would be...
You mean additional states besides Israel and South Africa?
That's right. So other states may eventually join these proceedings to support South Africa. They may join these proceedings to support Israel. It is not outside of the realm of the possible as well that parallel proceedings might be brought against other states in relation to events in Gaza. It's really unknown. We're really in the realm of the unknown at this stage. What we do know is simply this. South Africa has instituted proceedings against Israel. Hearings will take place for provisional measures on very short order, within a week, beginning on the 11th, so just after a week from now or so. And it is very likely that the court will issue a provisional measures order, and that order will be focused on preserving the rights of all parties, but most importantly, the subjects of the litigation being the Palestinian people on the ground in the Gaza Strip, preserving their rights to be free from genocide, to life, etc. And that's I think what is driving the South Africans to get the court to order the parties to cease fire, to order the Israelis to cease fire. The question is whether or not they do so.
I was going to say that does indeed appear to be South Africa's objective, and you seem to believe that it has a fairly good chance of success. But I think even before the court meets, we can probably also conclude that if South Africa gets its way and the court issues such provisional measures, that Israel will act as if nothing happened and will continue with its onslaught on the Gaza Strip. And in that case, the ICJ has no ability to enforce its provisional measures. Is that correct?
That is true. The ICJ, not only in this case, not only in respect of the provisional measures phase of this case, but the ICJ as the principal judicial organ of the United Nations has no ability to enforce its orders, judgments, et cetera, rulings, and relies on states to do that. So again, this is one of the limits of international law. It's based on state consent.
Mhm.
And Israel has consented to the jurisdiction of the court by virtue of its membership in the convention itself. It has not entered any reservations under Article 9 of the convention. It, to be sure, will have arguments to bring before the court to suggest that the court does not have jurisdiction to hear this case. But on the assumption that the court does issue a ruling on provisional measures and indeed a ruling on the merits, it will be left to states to ensure the adherence by Israel of its obligations here. And so this would be the General Assembly. This would be in individual states, domestically as well as internationally, engaged in looking and revising their policies vis-a-vis Israel. And I think that is an accepted, if you like, approach of the South Africans. My guess is that the goal of the provisional measures order, or any order that eventually issues, will be to put pressure on third states, just knowing full well what Israel's position is vis-a-vis the international legal order. And, for instance, in respect of the advisory opinion that is now, proceedings that are now before the same court, which hearings will begin in February, just a
Concerning
month
the legal
after.
status of the Israeli occupation.
That's right. In respect of those proceedings, the state of Israel has expressly qualified those proceedings as terroristic. So I think the South Africans anticipate that the Israelis won't respect an order of the court, but the goal is to put pressure on third states, ideally the Biden administration, to say, hey, cease and desist your provision of diplomatic, military materiel, et cetera. Otherwise, you will be implicated. Indeed, you are implicated in the commission of genocide, or the potential commission of genocide in Gaza.
Well, it does seem to be the position that of Israel, the United States, and the European Union, that Israeli impunity is the most important element of customary international law. But that notwithstanding, if we now turn to the details, you have read through the South African application. Did you find it a compelling document? Did you find it a work of polemics? What did you make of it?
No, a great question. I was in touch as well. Not only did I read the document, but I've been in touch with counsel for South Africa as well. And I should say, it's an 84-page document that, given the time pressures that the South African team were under, is a very strong document. This is a serious case for which Israel must tender an answer. And I have every confidence that the Israelis will. They'll tender an answer, a series of answers, and their answers will too need to be taken very seriously. But it is a strong document. I mean, it begins by affirming, as any case would, that the court has jurisdiction in the matter here, jurisdiction by virtue of Article 9, that there is a dispute between Israel and the South Africans as to the interpretation and the application, et cetera, of the convention. But it has to prove the existence of a dispute. And so it goes through the process of explaining what South Africa's actions have been over the course of the past month and a half to engage with the international community, but also to expressly state its position publicly at the multilateral level, in the United Nations General Assembly, at the UN generally, or in the public, and also bilaterally with the Israelis through note verbal sent to the Israelis, I think in early December, or rather on the 21st of December. All this to say, they have gone through a very careful process of explaining that there is a dispute between Israel and it on the interpretation of the convention, and that the acts alleged do entail the convention, the material elements of the convention, and so on.
In other words,
And
that they can concern an act of genocide.
indeed. And by virtue of those things, the court rightfully concedes itself of the matter on provisional measures. And then it goes into even greater depth on the genocidal actions undertaken allegedly by the Israelis since the 8th of October in the Gaza Strip, and coupled with the intent elements. There's a 4 or 5, maybe 6-page section of statements issued by the highest levels of Israeli government, including the Prime Minister of Israel. I'm looking at the document now, who on the 28th of October, 2023, as Israeli forces prepared to invade the Gaza Strip, invoked the biblical story of the Amalek, stating, "You must remember," he said, "what Amalek has done to you, says our Holy Bible, and we do remember," he affirms. And anybody who knows their Bible, as I'm sure battalions of the IDF do, will know that the relevant biblical passage reads as follows, quote, "Now go attack Amalek and proscribe all that belongs to him. Spare no one, but kill alike men and women, infants and sucklings, oxen and sheep, camels and asses," and so on. So this is but
And this
one
is a
such.
prime minister of the accused.
This is the prime minister of the respondent state, Israel, having said this to his soldiers and on more than one occasion. And then there's the president of Israel, who on the 12th of October stated in a press conference to foreign media that there's really no difference between the civilian population of the
They're all
Gaza Strip.
guilty.
They're all guilty. He said, quote, "It's an entire nation out there that's responsible. It's not true, this rhetoric about civilians not aware or
You're
not
quoting
involved.
verbatim now.
I am. It is absolutely not true. We will fight until we break their backbone," end quote. And so if for those who are watching, I would encourage you to have a look on the ICJ website at the South African submission, and you will see, beginning at page 59, you'll see a series of statements that have been documented, cited by senior Israeli leaders that evince an intention to destroy in whole or in part members of an ethnical, racial, religious, or
Because
not.
getting back to the earlier part of our discussion, simply describing criminal conduct by Israel towards the Palestinians in the Gaza Strip is only part of the story. The South Africans also have to prove or demonstrate intent, and it really struck me how much effort and how much detail this application contains in trying to demonstrate that there was an intent behind the actions, which are also very carefully described.
That's true. It is striking, but make no mistake about it, Mouin. Creative lawyers will come up with all manner of arguments in defense of the respondent state to suggest that these statements need to be taken, so will go the argument, in their proper context. They are cherry-picked, for instance, or there might be other aspects or actions undertaken by these very individuals around these statements to suggest that they do not evince on the high standard required on the merits phase of the case. They do not evince an intent to destroy in whole or in part members of a racial group, et cetera, ethnical group, and so on. And so we need to keep in mind, very, very importantly, the difference between the provisional measures phase of this case, whose evidentiary threshold is low, plausibility. Is the claim being made by South Africa plausible, right? And I would suggest to you, based on the evidence before the court proffered by the South Africans, it is most definitely plausible. It does go beyond that threshold. It reaches that threshold and goes beyond it. There will be claims made by Israel that the court doesn't have jurisdiction. I keep saying we'll get into it, which we will in a moment. But it'll be different when it gets to the merits phase. And there's a lot of contingencies out there. We don't know what we don't know. There might be other evidence publicly available. There might be evidence that is not available publicly. There might be evidence that emerges over time, including in
Sorry,
days
you
ahead.
mean evidence in the possession of the South Africans that they're withholding for the merits phase?
No, evidence in the possession of the Israelis that they may have to demonstrate that, in fact, these statements can be better understood.
No.
That is to say, can be explained reasonably through in any other way, because on the merits phase, the threshold is simply this: if there's any other reasonable explanation other than genocidal intent, then you don't have genocide made out.
Yeah.
Right. So let's think about some of that. For instance, the Israelis will say, well, when we referred Yoav Gallant, the Minister of Defense, when he referred to the Palestinians of Gaza, or so I understood it to be, human animals, he may very well argue, and his state will argue on their behalf, that they were referring to the Hamas paramilitaries. I'm not telling you now one way or the other how the court will find. And keep in mind, the court is a political court, right? That is to say, yes, the judges are independent. They perform a judicial function, but they also represent if you like, they come from different legal systems elsewhere in the world, and some of them come out of their foreign ministries, right? Judge Donahue, for instance, the American president of the court, came out of the State Department. The next president of the court, who I believe, well, I won't even surmise on that for now, but at any rate, so it is within the realm of the possible that there will be more conservative judges who see things differently when having the evidence put before them by the Israeli respondent on the merits. So again, that's I'm only surmising there, but there's no telling where that will go on the merits.
And speaking of evidence, this court has no way to compel Israel to produce evidence that the South Africans would like to see in terms of preparing their case. This doesn't work like domestic courts.
Well, the court can order the Israelis to provide, to undertake any number of actions, including provision of documents, including at the provisional measures phase, to collect, preserve documents, documentary evidence, to not destroy those documents. The court is well within its rights, and has done in the past, to issue such provisional measures as part of its provisional measures orders. That's not to say that they can enforce that order. That's another matter. And there's no telling what the Israelis would do. But what's unique here as well, which I think is self-evident to everybody, is the level of public attention this event
It really is the
having.
court of public opinion.
Yeah, in a sense, but you have a lot of evidence in the public realm, which now the very difficult job of the Israeli lawyers will be to impugn somehow, because there are quite literally hundreds of statements that either evince genocidal intent on the part of the Israeli high command, or indeed evince incitement to commit genocide by members of the Israeli public, their media, civil society, even entertainers, and so on. And that is met by a failure on the part of Israel to prosecute prosecute or prevent or punish those who are engaged in such incitement. So there's a lot out there, and the Israelis will do their best to defend themselves. But as I say, at the provisional measures phase, the Israelis will argue that there is no dispute. That South Africa, yes, has made these statements publicly, but that Israel has not bilaterally engaged with South Africa in this. There was, yes, a note verbal sent by the South Africans on the 21st of December to Israel, but Israel has not responded to it. Indeed, the Israelis will likely argue that the South African actions launched some 7 or 8 days after the note verbal was issued did not provide the Israelis with enough time to respond, they'll argue, and therefore there's no dispute. The South Africans will then look to the jurisprudence of the court to say you don't need to have a direct bilateral communication. It does not need to be evinced, this dispute, through an expressis verbis sort of engagement. It can be implied through the actions of the parties, and the actions here are clear. Israel has publicly said that it is not engaged in genocide, including at the UN, in the same multilateral forum that South Africa has asserted the exact opposite position, and that therefore the court can rest an argument that there is an implied dispute enough to allow it to issue a ruling on provisional measures at this stage of the game.
You've very carefully read the South African application. You're deeply familiar with the relevant international law and genocide convention, and you're also familiar with the International Court of Justice. Would you feel comfortable arguing this case?
For South Africa,
Yes.
yes, I
Mm.
would. I would feel very comfortable arguing the case.
Because?
Because the evidence is overwhelming.
Mhm.
Just because I'd mentioned earlier that Israel will have a defense, that does not mean that there is not a strong case to be made, case to answer for on their part. And so, based on the information available, as set out by the South African application, it is a strong case.
And you're, I presume, also assuming that the evidence will just continue to pile up by the time it gets to the merit stage.
I think the answer to that is twofold. The material acts required, the actus reus required for genocide will continue to pile up. So starvation will continue, perhaps not at the same pace. Um, Bombardment will continue, again, perhaps not at the same pace. But I think those actions are leading us in one direction. On the other hand, the requisite mens rea, or the mental element, the intention element, I think the Israelis have been put on notice, and over the past 24 hours, I think you've already seen it in the news. There's been discussions at cabinet level to ensure that all members of cabinet keep their mouths shut. And so they're going to try and dial back or pull back on public statements that might
Well,
feed the case.
well, I wanted to ask you about that because what struck me is that virtually the day after South Africa filed its application to the ICJ, you saw Israeli cabinet ministers openly talking about depopulating the Gaza Strip. The Minister of Finance said we need to reduce the population from 2.3 million to only 1 to 200,000. Now, I know that these statements don't directly speak to the issue of genocide, but to kind of run their mouths like that immediately after being accused, to me, demonstrates an extraordinary level of confidence of, well, it demonstrates not only contempt for the international community and the ICJ, but also a confidence that they can do whatever they want because at the end of the day, impunity is theirs.
That certainly is one read. I tend to think, and I don't disagree, that there is a contempt in Israeli civil space and certainly public governmental space, a contempt for the rules-based international legal order and the United Nations and so on. They don't hide that. But I should think that those statements were just statements by individuals who aren't very sophisticated and don't appreciate the legal import of what it is they're saying. I should say this as well. Those statements on their own don't evince genocide, as you've mentioned. You know, so you can have crimes against humanity, you can have war crimes, and it's almost invariably the case that you do, short of genocide in a situation that might look like genocide, but isn't, the key issue being the requisite intent. So here, as I say, I anticipate the acts to continue over the course of some months and perhaps a year or more. And the Israelis are open about that. They've driven 85% of the population of the Gaza Strip south. The scorched earth tactic has rendered the north and middle areas of the Gaza Strip unreturnable to, if you like, because there's nothing to return to. I think 65% of the housing stock in the Gaza Strip has been destroyed or unlivable, rendered unlivable by the bombardment. And then the starvation as a tool of war will continue. So you'll have those acts. I do think that the government of Israel will clamp down on anything that might even remotely look like intent or underscore the intent element, for fear that that would feed the case in this case. Mind you, as I say, there are hundreds of such statements that predate the institution of these proceedings by South Africa. And so there's enough there to go on. It's a strong case, but I wouldn't put my hands on a crystal ball to say that on the merits it's genocide. That's 3-4 years hence. A provisional measures order will issue, though.
So 3 or 4 years hence, the judges of the International Court of Justice will issue their ruling, either confirming that it is genocide or rejecting the South African application and saying this may be terrible, but it's something else and it's not genocide. What are the pros and cons of the ultimate decision? What would be the pitfalls of having brought this case if the ICJ rules against South Africa? And what would the benefits for the Palestinians be if genocide is confirmed?
Well, the pitfalls are political, in my respectful view. But it's hard to it's important for us to separate the material, right? The very difficult position of the millions of Palestinians who are on the ground in Gaza subject to what appear to be genocidal actions and so on, and the politics side. But so one pro of bringing the case would be to act immediately to cease fire. The key request of the international community since the first week of events, in the second week of October, was to impose a ceasefire, knowing full well that as long as the hostilities continue, as long as the bombardment that is pretty much undefended continues, as long as the starvation continues, there will be a greater likelihood of genocide, of, at the very least, war crimes and crimes against humanity, starvation and forcible transfer, basically the ethnic cleansing of the Gaza Strip, would be made much higher. And so that seems to me to be the imperative as to why the South Africans have brought this case, because if you get a ruling on provisional measures that orders the parties to cease fire, that orders Israel to cease fire, then that will add, if you like, weight to the call to pressure third states to ultimately, and the United States to ultimately pressure Israel to
So
cease fire.
rather than seeking to achieve provisional measures in the false hope that Israel is going to stop bombing once such a ruling is issued, it's more something that can generate political pressure on those who are thus far resisting the call for a cessation.
Yes, that's right. And yes, I'm speculating on that, but that I think is a reasonable speculation to make. Another one, say you ask about the con. Well, the international community, especially the Western world, has been pressuring, since Srebrenica, holding itself out as the standard bearer of the rules-based international legal order, and using the International Court of Justice in cases against Syria, against Iran, and including in cases against Russia under the Genocide Convention. This includes submissions supported, I think, by the Canadians, the Dutch, I think the United Kingdom and Denmark. They supported Ukraine in its filing under Article 9 of the Genocide Convention, a dispute against Russia and so on. And so they're holding themselves out as being, the guardians of this order. And now the South Africans, a paragon, a very important player from the global South, are, acting under the same, if you like, idea. And one of the cons of not acting as a leader of the global South would have been to have the history, have the judges of history, if you like, fingers pointed at them. They had to act. And it also, by acting, puts pressure on these third states to say, okay, now put your money where your mouth is. Do we have a rules-based international legal order? Is it international law, rule of law for everyone? Or is it just for some? And so that's a potential con. Let's say that the case goes forward on its merits, and the court in the end says, no, this isn't genocide. It's horrible things, crimes against humanity, war crimes, but it doesn't meet genocide for whatever evidentiary standards that have yet to be met or have not been met. Then that might be a political fail, if you like, but one, in a sense, that was brought to the South Africans, brought to the international community, not through their own actions, brought to the Palestinian people through no fault of their own as a people, as such, but because of the actions of Israel, which, by virtue of these statements, by virtue of these bombardment and so on, required action and at this time. So it's a tough case tough question to answer, but you can see the thinking behind why the case was brought. People's lives are on the line.
Well, given that, and since we are talking about the political dimensions, and you said, you know, it was required to bring this case, were you surprised that it was, or that it is South Africa that has taken this initiative, while
Yeah.
many other states closer to home, thinking, for example, Palestine's Arab neighbors and so on, apparently were too terrified of either Israel or the US or both to consider a similar initiative themselves.
Yeah, I have no opinion on
Mhm.
the reason why Arab states who are parties to the convention didn't bring the case. I have no basis on which to even offer a view on that. It's just speculation. What I can say is that the South Africans occupy a special place in the global South. And in, you know, politically, economically, but most importantly in the global sort of mind following the fall of apartheid. They have a moral authority by virtue of their struggles against apartheid that provides them with a special, if you like, responsibility that they readily accept and are making full use of. So it's one thing to say that, you know, Jordan or some other Arab state who might be party to the treaty has sued Israel for genocide. Quite another for the South Africans to do so, given what they represent, and not merely to South Africans, but to the global South as a whole. And so I think that that's why it was felt, at least in South Africa, that it was a move that was compelled for them to make. And I suspect that over time, over the next month to 6 months, we will see other states, other actors weigh in, either joining the case in support of South Africa, and they may include Arab states, who knows, or indeed other members of the global South. What we have seen already are statements of public expressions of support given by
Organization of Islamic Cooperation.
That's right.
Yeah.
And Malaysia, that's right. So Malaysia's done it, the Organization of Islamic Cooperation, representing some 50 plus members, member states of the UN. So you see those statements, and those things will have importance before the court. The court, again, as I said earlier, is the principal judicial organ of the UN, but because its members are drawn from different states, and some of them foreign ministries and so on, there's politics to this. They will stand up and take note of what regions on Earth, what countries on Earth, how many of them are actually weighing in support of the South Africans, et cetera. And that will figure, at least subconsciously, in how they rule, because they'll understand the weight of global opinion is one way or the other. They'll move in that. Well, that will influence, one would think, how they read the law.
So as a final question, but feel free if I've left anything out about the International Court of Justice you'd like to address. But for my final question, the International Court of Justice adjudicates disputes between states or provides advisory opinions on the conduct of states, but as you mentioned, has no enforcement or accountability mechanisms of its own. And then you have the International Criminal Court, which deals with personal rather than state conduct, and does have powers of indictment and trial and conviction and so on. In the event that the ICJ finds that Israel is guilty of genocide, does that automatically trigger anything at the ICC? As you know, many people have been appalled by the manner in which the current ICC prosecutor, Karim Khan, has treated the situation in Palestine with, at best, malign neglect. But would he be under any obligation, or would the office of the prosecutor be under any obligation?
No, as an independent actor under the Rome Statute, the office of the prosecutor and the prosecutor himself would be free to continue in assessing the situation as part of the investigation on the situation of Palestine as he sees fit and on the basis of the evidence in front of him and his team. However, there's no question that a ruling from the principal judicial organ of the United Nations, being the ICJ, that genocide has taken place, or that attempts to genocide have taken place, or that there has been an incitement to genocide, all of which are individual criminal actions under the Rome Statute. There's no question that a finding from the principal judicial organ in the ICJ of that would provide a great deal of wind in the sails of the prosecutor to act and to issue an indictment.
Suspecting we have Force 10 hurricane.
Yeah, of course. The real issue is, again, you have provisional measures, which again do not require at all for acts of genocide or any of those actions to be established at all. Again, that's just the provisional measures phase. And then you have the merits phase 2 or 3 years hence, maybe 4 years hence. And so it may be, because it won't be until 3 or 4 years from now that the ICJ will dispense with the issue of genocide, at least in respect of events taking place in the Gaza Strip since the 8th of October. It may be that that provides the office of the prosecutor with reason to not move on genocide in its investigation until such time as the ICJ dispenses with the matter. So that's actually one of the downsides of the ICJ movement. On the other hand, I'm sure that everybody, including the South Africans, who did make a referral to Karim Khan and the ICC about a month prior to instituting these proceedings at the ICJ, did make a referral with 4 other states to Karim Khan on genocide. I'm sure, and he hadn't moved yet. I'm sure the South Africans will take the view that, you know, Karim Khan needs a bit more pushing, and he's not likely to move without other pressures being brought to bear. Thus, that mitigates in favor of them moving to the ICJ for this action.
And just finally, you keep mentioning a period of 3 to 4 years. I presume that's kind of the standard practice of the International Court of Justice and such matters. It doesn't reflect in any way on this particular case or dispute.
It doesn't, based on the jurisprudence of the court, the Myanmar and Gambia matter, Bosnia-Herzegovina, Serbia, and Russia, Ukraine. It's between 2 and 3, or maybe even 3 and 4 years before the case on the merits is heard. And then, of course, you can have all manner of procedural impediments that are put up in the way along the way. Other states can join in, and so people should be prepared for a long haul on the genocide matter. Again, provisional measures are likely to be issued. It will likely be a both sides order, very general, designed to preserve the rights of all parties, but particularly the rights of the people of Palestine in the Gaza Strip to life. Whether or not that ends up imposing a ceasefire or helping to bring forth a ceasefire or a change in behavior of the occupying power is another matter altogether. More strategically looking ahead is the case on the illegality of the occupation, which the court will hear.
I was going to say, in the meantime, there is another case before the ICJ concerning Palestine.
Right. So there is another case. As I said, the case hearings in the case begin on the 19th of February. I will be in The Hague for that. And there, the issue before the court on a question put before the court for an advisory opinion by the General Assembly is simply a series of questions, but it is the nub of the question is whether or not Israel's continued presence in the occupied Palestinian territory is lawful, and if it isn't, what the legal consequences of that are. That's a more strategic case, and the court will dispense with that much sooner than the genocide matter. Hearings will take place in February, and perhaps the court will dispense with it by July.
That's indeed a much quicker pace of decisions. Ardi Imseis, I want to thank you once again for sharing your insights and expertise on this very timely and also critical topic with connections. Thank you very much.
My pleasure, Mouin. All the best to you.
Thank you.
Be well. Yeah.